Why, if I have a she file as a contractor and my client has signed it off and he allows me to work on site according to that she file, why would I want a proper health and safety management system? Well, you need to understand firstly what a she file is really and how it fits into a health and safety management system. And then you need to look at the Occupational Health and Safety Act, Articles 37.1 and 37.2, that talks about the owner or the employer's what we call vicarious liability. A health and safety management system is a comprehensive approach to provide safe systems of work for your employees for all of the organization's activities, locations, and clients. You need this to comply with Section 8 of the Occupational Health and Safety Act. A she file is not enough on its own to show that you are providing safe systems of work. A she file is really an extract from your health and safety management system that you need to submit to your client to convince your client that you actually have a health and safety management system in your organization to manage your health and safety risks for that specific project. And if you need to go to another project and another client, they want to see an extract of other items from your she file. If you are constantly just building she files, you don't have a continuous health and safety management system that will help you to drive towards excellence. Every time you are building a snapshot of documents which are often interrelated, they are independent, they don't talk to each other, there's no feedback system that links your risk assessment with your implementation, with your checking, and with your corrective actions, and you are basically just pretending and creating a false perception that you have a health and safety management system where you actually don't. Now let's look at what happens if what is my responsibility in terms, or what's going to happen with my senior management and the CEO in terms of health and safety. If you look at Section 37 of the Occupational Health and Safety Act, it deals with criminal liability of an employer for the acts or omissions of his own employees. Yes, breach of the Occupational Health and Safety Act, you can be held criminally liable for involuntary manslaughter and that kind of thing if somebody gets hurt or if they die. Now, even if you are not at work because you are the CEO or the employer of the company, or an appointee, a 16.2 assistant to the CEO in the execution of his duties, you can be held liable for what your employees are doing or not doing. That's called this is what we call a vicarious liability. So you can be held guilty or found guilty for things that your employees did even while you were on leave in Spain or in America, whatever, provided you didn't do certain things that needs to be done. For you as the employer not to be held responsible, criminally responsible and liable for acts or omissions of acts by your employee, you will need to show that in this incident that he was involved, where he acted or he omitted to act, he acted without the permission of the employer. In other words, he was following his own mind. And therefore you will have to show that he had certain roles, certain responsibilities, he had certain tasks, he was appointed for certain things, and he must not be able to show, but you expect me to do everything even if I'm not trained. You must be able to show that this person acted outside the scope of their employment. And if they have been expected to do that kind of work or take that kind of responsibility before and you accepted that, you will not be able to say that they acted outside of the scope of employment because previously that was good enough for you. The employer must have taken reasonable steps to prevent such an act or an omission. In other words, you must have done risk assessments, you must have identified the possible incidents, you must have identified the possible deviations, you should have put controls in place, checklists, training, supervision, operational discipline, disciplinary action, all of those kind of things for the work that this person had to do. And in the event that the employer cannot prove all three of those above points, the employer will be regarded as having committed the act and may be sentenced and convicted on the terms thereof, even if you were not even on site, because you carry the legal liability. Now, when you go and work on the property of a client, that client has the same kind of responsibility towards you as you have towards your employees. So if you do something as a contractor or as an employee or somebody that has been employed by a client, then the client, through Article 37.1, is now also vicariously liable for your acts or your omissions of acts, unless they put a special agreement in place between the client and the contractor. And that is specified in Article 37.2. In Article 37.2, the client will point out to you that they are not going to take any liability for your actions or misactions. You need to have a proper health and safety management system in place, and you need to manage your risks. You need to comply with all your legal duties like an incident reporting, risk assessment, and everything that you need to do according to Section 8 to provide safe systems of work. The contractor can also stipulate more requirements for you to comply if they expect that you don't have such a good health and safety management system. And this is where something like the SHE file comes in. Because they understand that small contractors don't always have health and safety management systems, the client gets a system in place where they cover their own base. CYA we call it, cover their own backsides. So what they do is they say, please convince me that you have a health and safety management system in place by giving me examples of this checklist and that checklist and this and this and this. And if you submit that to them, then they say, okay, you convinced us that you've got a health and safety management system as an employer in your own right, and we can now accept you and you will continue to work. But yet, you remain legally liable for your own troubles. Also, the client can then say, if you don't stick with this agreement and maintain this, then we don't want to engage with you anymore and we will stop doing business with you. So Article 37.1 and 37.2 are very important clauses. A lot of matters can be included in the agreement, like mandatory compliance audits, the inspections that they want you to do, pre-start checklists, and whatever the client wants you to do in terms of health and safety management to stay safe on their property. Now, even if you have an Article 37.2 agreement with the client, it's not going to be an indemnity against prosecution. So what is going to happen if a contractor has an incident? The investigation will look at the health and safety management system for the contractor or the subcontractor or the subcontractor. And if they don't have a proper health and safety management system in place, they will come one level up and they would look at the contractor and they would say, so what did you do to make sure that these guys remain safe and that they keep the employees safe against any harm? And if the contractor doesn't have anything in place, then they will still go back to the client. They say, but you allowed these guys, even with your 37.2 agreement, you allowed these guys to come on. So what did you do? How often did you ensure that they actually kept their health and safety file up to date? So you need a proper health and safety management system. You need more than just a SHE file. Every company, every organization needs a health and safety management system based on the risks and the legal requirements that are applicable to them. And they have to be able to show that they have done whatever they could to enable people to keep themselves and others out of harm, including risk assessments, training, awareness, and everything that goes along with that. And you need to have the records to prove that. And you need to show how these records are used to reduce the risks. So having a lot of disconnected documents in a SHE file that is not working systematically at the system is not going to be sufficient if something goes wrong in your organization.